Can you guess who the lawyer in the room is? Before I, my assigned speech is on a little case that went before the United States Supreme Court not too long ago called Glossop versus Gross, which is the lethal injection case. But before I talk about that, I just want to say that it is always an honor and a privilege to be with Harold Wilson. Harold was my client in Pennsylvania, and we were trying for the longest time to get an evidentiary hearing for him on questions of guilt or innocence, because we had read in a newspaper that the murder weapon had been found at the crime scene. And we had a couple of newspaper clippings that said this, but by the time of Harold's trial, the murder weapon had been found in a sewer halfway between the house in which the murder occurred and the house in which Harold lived. And it seemed to us that that was somewhat odd, that after the murder had been committed and the police had identified the weapon at the scene, that it somehow got up and moved itself, and did so in a manner that pointed directly towards his house, and did so in a manner in which the evidence that they had found it at the crime scene never showed up at trial. We tried to get an evidentiary hearing on the guilt issues, and we were denied the hearing. So we were proceeding solely on the question of whether Harold should live or his death sentence should be carried out. And during the course of the hearing, we presented a whole lot of evidence because his lawyer did not do much of anything in the case. We persuaded the judge that Harold had received ineffective representation on the question of whether he should live or whether he should die. There was a moment in the hearing when Harold is sitting next to me, and the defense lawyer from the trial, who later became a judge of the Philadelphia Court of Common Pleas, actually, in fact, when he was testifying, he was already a judge on the Court of Common Pleas. He admitted some of his failures with respect to investigating issues of life or death, but there was a point in which, to defend himself, he invented a story. And we're sitting there and we're listening as he said that he received a panicked phone call from Harold saying that he confessed to the murders. And Harold leans over to me and says, "He's lying." Yeah, and I'm thinking, yeah, he probably is. But keep quiet, don't annoy the judge. This is a penalty phase hearing, and that part of it is going well. Right? But we know full well that there is testimony that just doesn't comport with reality. And even though what we're working on at that very moment was to make sure that Harold's life was saved, we also had to look ahead because we weren't going to give up the question of whether he had been fairly tried. One of the issues that we raised was the question of the Philadelphia District Attorney's Office discriminating in jury selection, striking African American jurors. And Harold's lawyer had raised that issue at the time of trial, but he'd been turned down. We raised it again, and we were told, you can't raise this issue now because you had previously raised it to the court. So it's a doctrine called previously litigated. It's a way to make sure that when you discover new evidence on another topic, you don't get to present it to the court. So we won on penalty phase, and we appealed on guilt. And the district attorney's office initially appealed as well. And then during the course of all these proceedings, there's this videotape that comes out that is disclosed on March 31st of 1997. There is a press conference on April Fool's Day, April 1st, in which the district attorney reveals the tape publicly. And the reason it came out at that particular time, if you are a conspiracy theorist or a political strategist, is as follows. Jack McMahon, the prosecutor who prosecuted Harold, was running for district attorney against Lynn Abraham. He was running for the Republican nomination. He was not having any opposition in the Republican primary, but the training tape was somewhat embarrassing. What happened was, just after the filing deadline was over, so that nobody else could file nominating petitions to get the Republican nomination, with Jack McMahon as the sole Republican candidate, boom, the tape comes out. And so we filed another claim based on the tape. Give us a hearing because we have new evidence and this evidence is completely different. Harold's case was the first case in which we raised the evidence from the study by David Baldus about racial discrimination in the imposition of the death penalty in Philadelphia. And that was the study that showed that if you were capitally charged, the odds that a defendant would be sentenced to death increased by a factor of 3.1 based on one thing, the color of your skin. And if the case proceeded to trial and you were convicted and the case went to a penalty phase, the odds, if you've gotten to the penalty phase, that you would be sentenced to death increased by a factor of more than 9 based on one fact, and that's the color of your skin. And among cases that jurors found an aggravating circumstance, a reason for death, and a mitigating circumstance, a reason for life, and they were given the discretion to choose between whether a defendant should live or be sentenced to die, the odds that they would exercise that discretion to take a life increased by a factor of more than 29 based on one fact, the color of his skin. We did not get a hearing on that issue. But when we were appealing, the landscape had changed. And when we were appealing, it was getting very difficult for the Pennsylvania Supreme Court to say, well, wait a second, we are going to overlook the fact that there is a smoking gun. There is a videotape that explains how to invent false reasons to justify your striking a juror because he or she is black. And we got the Pennsylvania Supreme Court to send the case back for hearing on that issue. When it became clear that the judge was going to let us put on a whole bunch of evidence that the district attorney's office didn't like, they appealed, they tried to take it back to the Pennsylvania Supreme Court to limit the evidence that we were allowed to present. And we went with this long back and forth that took, I think, a couple of years before we eventually did have our evidentiary hearing. And at the close of the hearing, and one of the most, it was interesting because the judge had two post-conviction cases in front of her. One was a gentleman by the name of Robert Cook, and one was Harold's case. And they were both prosecuted. Well, William Basemore had his hearing in front of Judge Savitt, which was a very interesting hearing, and we watched it with great interest because it was the first time that Jack McMahon was on the stand. And we watched and listened to the explanations that he gave and took very, very detailed notes because we would have a chance to put him on the stand. Counsel for Robert Cook was a gentleman by the name of Jules Epstein, who was a really, really nice guy. And I was Harold's lawyer. And I like to think that I'm a nice guy, but we played good cop, bad cop, and because Jules was nicer than I am, he got to play the good cop. So he's asking Mr. McMahon a number of questions. Did you really mean this? Did you really mean that? So Jack McMahon is denying that he's acting in a discriminatory way. And I get up and I say, did you say that because he's black? Did you strike that juror because she's black? When you say them, when you're training, you're dealing with them as jurors, did you ever use the word them when you were talking about jurors who are white? And so we, piece by piece, pulled out all the different facts, showed how he did exactly in this case what he said you should do in the training tape. And at the end of the day, Harold got a new trial. People talk about death penalty cases being reversed on technicalities. And first, I don't think it's a technicality that somebody's constitutional rights are violated. And I especially don't think it's a technicality when a prosecutor's office is systemically striking jurors on the basis of race. Our study showed that over a 20-year period, in the exercise of 14,000 choices whether to keep or strike a juror, and we knew the race of 12,000 of the jurors, we were able to show that the Philadelphia District Attorney's Office struck black jurors with twice the frequency of everybody else. And we were also able to show, and this is why I've never been able to serve on a jury, that they struck white jurors who grew up in integrated neighborhoods with twice the frequency of jurors who lived in highly segregated white neighborhoods. And this was a game changer. And it changed the entire background. But you talk about technicalities. We wanted a hearing on Harold's guilt or innocence. We wanted that. Harold said from the beginning that there was the killer's jacket, and this was fresh after O.J. Simpson. He was going to put it on and we're going to show that if the jacket don't fit, you must acquit. Of course, Harold's a little larger at that point than he was at the time of the trial. We were told that they couldn't find the jacket. And we didn't have a constitutional violation relating to the jacket, and this wasn't trial, so we weren't entitled to discovery, so we had to accept the word that they didn't have the jacket. So we get a new trial on the technicality that they violated Harold's rights by engaging in racial discrimination in jury selection. And when he gets that new trial, lo and behold, guess what happens? They find the jacket. And why is that important? Because they actually thought that Harold was the killer. And there were such huge advances in DNA in the 15 years in which the case had been running through the system. They intended to get the DNA testing and then spring on us at the new trial that, look at this, we can prove that Harold Wilson is the hatchet murderer of 3 people in a crack house. And they got the DNA, and they did the testing without notifying the defense. They don't have to. It's their evidence. And the evidence came out, and there was blood from 4 people, which you would expect with a triple murder with a hatchet, right? I mean, somebody is going to get the perpetrator. Their blood is probably going to be somewhere on their jacket. There's blood. It's 4 people. 3 of them are the victims, and the 4th is not Harold. And they retry him anyway. And he gets a mistrial. The lawyers at trial are able to get the judge to bar the death penalty because after all the passage of time, our witnesses who can tell the story of Harold's life are not available. And so it's unfair that he should be encumbered by the constitutional violation when they discriminated against him and against the jurors. So the judge threw out the death penalty. And with a new trial without a death-qualified jury, Harold was acquitted. So it's always a pleasure to appear with Harold. Now, let me tell you about what I'm supposed to talk to you about. And that's this very, very little and inconsequential case called Glossop versus Gross. Glossop, from the beginning, was a small case, or so we thought. It did not challenge the constitutionality of the death penalty. It did not even challenge the constitutionality of lethal injection. It was all about whether one particular chemical, one particular drug, midazolam, was unconstitutionally used by the state of Oklahoma as part of a 3-drug protocol. Midazolam is a drug that is an anti-anxiety drug, think Xanax. It's not a drug that gets used in extended surgeries to put you to sleep and keep you unconscious. It doesn't have that ability, and all the scientific evidence shows that it doesn't have that ability. It can put you to sleep, like most lawyers do when they talk, but unlike that, you are jolted into consciousness when you are exposed to other painful stimuli, such as the chemicals that are used, chemicals 2 and 3 in the Oklahoma Protocol that Justice Kagan and Justice Sotomayor described as being chemically burned at the stake. So when you are being chemically burned at the stake, you are jolted into consciousness. And so long as you are conscious, you are experiencing excruciating, searing pain. And the question before the court was, is that protocol that's used by Oklahoma cruel and unusual punishment? It's not, is the death penalty unconstitutional? It's not even whether Richard Glossop should live or die. It's, should Oklahoma be permitted to kill him by means that are objectively torturous after we have seen botched executions in Ohio, in Arizona, and in Oklahoma itself? So that's the issue. What's all the hype about? We go to the Supreme Court, and the justices, during the oral argument, displayed a level of emotional involvement in this case that I've never seen. You had justices who are proponents of the death penalty, who were acting as though what was at stake was the death penalty itself. Not, is this chemical inappropriate in this context? But, and the language was, is there a guerrilla war against the death penalty? Now, one of the questions that court observers had is, would they have said that in any other context? If there were any other issue before the court, would the issue have been framed, is there a guerrilla war against this policy, and because of the actions of unnamed anti-death penalty activists, based on unnamed conduct that had never been reported to any authorities that ostensibly consisted of harassment, was this a reason why these guys who were on death row, who had nothing to do with any social activism or political activism relating to the death penalty, should be denied the constitutional right not to be tortured to death? Would that have happened in any other context? And most court observers think that it would not. But that's not the only place that there was a lot of emotion. There was also a lot of emotion on the side of the moderate and liberal justices who were appalled at the prospect of burning somebody at the stake, whether by chemicals or any other means. And Justice Sotomayor took to task the lawyers from Oklahoma for what she considered misrepresentations in their brief. It was a very, very contentious argument. So we left the courthouse, and the press starts asking, well, what's this about? And I say, this is a small case. It's always been a small case. The legal issue is very narrow. It's only about midazolam and the way it's being used in Oklahoma. But what was beginning to become clear is that psychologically, there was something more that was at stake. And the proponents of the death penalty on the court were speaking not just words, but in tones that suggested that they believed the institution of the death penalty itself was under assault. And they would do so, I would submit to you, only if they had the sense that the death penalty as a policy was beginning to crumble. So we wait for the opinion, which, this wasn't the most important opinion of this term. I mean, gay marriage was more important than this opinion. The housing issue may have been more important than this opinion. The redistricting was more important than this opinion. But all of them were decided before this, which meant there was something very important that was going on. Either somebody hadn't made up their mind yet in a close vote, or somebody was writing something that was going to be monumental, momentous. The decision came down, and if you look at the decision itself, the holding of the court, what the case actually means as a matter of law, it is a small case. It's a small decision. It doesn't say the death penalty is unconstitutional. It doesn't say lethal injection is unconstitutional. It doesn't even say midazolam is unconstitutional, and it doesn't even say that midazolam is constitutional. The ultimate holding as a matter of law in this case is that the lower court judge credited the testimony of the state's expert who had done research about midazolam on www.drugs.com. And based on his internet research, he concluded that if you give maybe 5 times more midazolam to the next guy than the guy who was tortured the last time, he is going to remain, the word is insensate, that is to say, you don't feel pain, you don't feel anything, you are completely knocked out, you're impervious to sensation. And the district court judge said, I accept those facts. I've read children's stories in my life, and I think that some of you may have also. And Alice in Wonderland comes to mind, particularly through the looking glass, where Tweedledum and Tweedledee are talking, and one says to the other, and I don't remember which is which, but that's, I think, the point of Tweedledum and Tweedledee. One says to the other that words mean what I say they mean, nothing more and nothing less. And it seemed to me that what the district court did here was listen to the words from the expert that Oklahoma presented and decided that safe and effective meant what the expert said it meant in the face of what everybody else who had open eyes had seen. Because America has seen the botched executions in Ohio and in Oklahoma and in Arizona. We have seen that there are people being executed who are gasping and flopping around like a fish, according to the descriptions of the media. We have seen the blood flying out of their bodies as the state of Oklahoma misses the right vein. And we've seen them pull the curtain down so that you don't have public display of what was happening, despite a state law saying that you have to have witnesses to what's going on in an execution. So we have seen the facts. And the fact-finding here looked an awful lot like fact-finding through the looking glass. The question was, what's the United States Supreme Court going to do about it? And it was 5-4. And 5 justices of the United States Supreme Court said that they were limited by the rules of appellate procedure in what they could say about facts. The issue was whether what the district court judge found was clearly erroneous. A legal term that simply means, was there support in the evidence was there support in the evidence of record for the finding, the conclusion that the judge reached? And there certainly was, if you accept the testimony of the state's expert, which, as America saw, having looked beyond www.drugs.com and looked directly in the face of 3 torturous, botched executions involving midazolam. Well, it sure looked like the fact-finding was clearly erroneous, but the court said it was not. The court said it was limited by the nature of its appellate review, and that creates a problem. I believe that the American public, who already have doubts about the ability of states to carry out this important policy fairly, accurately, competently, I think that this opinion is going to further undermine public confidence in the death penalty. It's also, I think, not good for the public's view of the federal courts, because we want our courts to avert injustices. And when you have seen the injustice of people being torturously killed in incompetently administered executions, you want the courts to say you can't kill people in that way. So it's a limited decision in what it says substantively, but I think it further erodes public confidence in the death penalty at a time in which public support is at a 40-year low, and the number of executions are at a 20-year low, and the number of death sentences are at a 40-year low. The other thing that this did, and this goes along with the heightened level of emotion during the oral argument, is it produced what I believe will be an historic decision, at least an historic opinion, from Justices Breyer and Ginsburg, in which those justices invited lawyers to file court actions challenging the constitutionality of the death penalty as an institution. And Justice Breyer's opinion is a blueprint for what that challenge might look like. People being sentenced to death unreliably. What does he mean by unreliably? Harold Wilson, number 122 out of 154 people who have now been exonerated from death row. A death sentence is unreliable if you convict and sentence to death somebody who's innocent. And Justice Breyer notes that there have almost certainly been executions already of people who are innocent. So it is unreliable. It's also unreliable because of race bias. It's also unreliable because of economic bias. It's also unreliable because of the absence of sufficient resources for good lawyers to be handling cases. And these are all things that Justice Breyer points to. That is part of the roadmap for challenging the death penalty. It is cruel, Justice Breyer says, if those facts are proven. It is cruel because it is arbitrary. It is also cruel because of what Harold experienced over those more than 15 years in solitary confinement. Being kept alone 23 hours a day with no contact visits with your family, with an hour in the yard, in freezing conditions sometimes and sweltering conditions in others. That is not good for your mental health. And that is something that Justice Breyer says is cruel in itself. So we have cruel, what about unusual? Justice Breyer says there is a trend in this country. And he cites our website 17 times. Well, 16 times. 16 times. Sorry, got to fix that one. About the history of what's happening in this country. There are now 31 states that have the death penalty, down from 38. There are another substantial number of states who have not executed anybody, he says, in 8 years. You're now looking at a majority of the United States that has either abolished the death penalty by law or is not implementing it in practice. He said that at the time that the death penalties were restored in the 1970s, upwards of 2/3 of Americans lived in counties in which death penalties were sought and imposed. And that a large majority of Americans today live in counties in which it is not sought and is not imposed. Executions are down, death sentences are down. Indeed, in the execution capitals of the United States, Texas, at this point this year, there have been 0 death sentences in the state of Texas. And there have been no death sentences in Virginia in the last 2 years. So what we're looking at, Justice Breyer suggests, may be an evolution in American thought and American society. And with the Eighth Amendment being governed by the evolving standards of decency, as reflected in indicia of social values, whatever that means. Well, what it means is what legislatures are doing, as in Nebraska, as in maybe Montana, because Justice Breyer says they missed by 1 vote, or New Hampshire, where they missed by 1 vote, or Delaware, where a bill to abolish has passed the Senate, may have enough votes to pass in the House, but is being held up in a committee. All of these movements, he says, are in one direction. We are seeing change, and that change is away from the death penalty. That, he says, is another indicator that the death penalty may be unconstitutional. So Glossop is a small case when it comes to how you go about killing people who are on death row. But Glossop may have a legacy. And that legacy is not going to be the majority opinion, but it's going to be how the court responds when lawyers respond to the blueprint that Justice Breyer has laid out for them. Thank you.
I'm afraid to give you any questions. But what do you think the timetable is?
I'm notoriously bad at predictions. Okay, so anything I say is going to turn out not to be true. There are a number of places where a court action could be expected. The federal district court in California has already declared California's death penalty unconstitutional as applied, and that case is being briefed right now in the Ninth Circuit Court of Appeals. We will have argument probably in that either sometime this fall or next year. It is possible that that could be a vehicle to raise a number of these issues. I think that there are a wide range of other states in which the manner in which they provide indigent defense raises serious constitutional questions, and that in conjunction with evidence of discrimination in the manner in which death penalty is sought, and the manner in which it's imposed, can make challenges ripe. So I think we will see challenges started in the next couple of years. It's hard to say how soon it will reach the court. I would say that, I'm getting old. In 1989, when I was on the Georgetown Law Journal, they asked me to write about the Eighth Amendment and what I thought the future of the death penalty was. And I think the answer I gave then is exactly the same answer that I would give today. And that is, the future of the death penalty is whatever the composition of the Supreme Court turns out to be. And we're at 5-4, and we will see, probably with the next presidential election, which way this goes.